Good afternoon, everyone. My name is Kathy Purdy. I'm a marketing manager at Schoeneck King. I'd like to welcome you to this week's coronavirus webinar presentation. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows. Once the presentation has ended, if you would take a moment to complete the brief survey, we would appreciate it. Our presenters do look at your comments for future program topics and appreciate your input. So to start things off, I'm going to hand it over to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. It's good to be with you again. We've got a full program for you today, so let's hop right in. We're going to start with Liz Lehman. Liz is in our Syracuse office, and she's going to just offer some comments and bring us up to date on the PPP program. Liz, take it away.
Thank you. Now I'm unmuted. Hi, everyone. Good to be here today. My name is Liz Lehman, and I have been helping clients with the PPP since the start of the program. So today I want to give a couple updates on the status of the PPP, both the first and second draw applications, as well as then I wanted to address some more pointed questions that we have been getting from our clients. So first, the status of the PPP. Yesterday, the Biden-Harris administration issued its first comprehensive guidance piece regarding their stance on the PPP. And it is clear that the new administration is focusing on the smallest and most distressed organizations that may have not been eligible to apply for the PPP in the previous administration. However, the biggest takeaway from that guidance was that starting tomorrow, there will be a 2-week period where only businesses with 20 or fewer employees may apply for the PPP, presumably both the first and second draw. However, keep in mind that after that 2-week period, the program is still open until March 31st. However, I encourage that if you have more than 20 employees and are considering whether to apply for the PPP or not, to contact your lender today or contact your attorney. So that's the broad stroke of the new administration. I also wanted to very briefly touch upon another grant program that was established by the recent Stimulus Act, which probably doesn't apply to a lot of you folks out there, but the Shuttered Venue Operators Grant, which is a grant versus the forgivable loan that the PPP is, and it is administered directly by the SBA. So that program is not live and not up and running yet. They are not yet accepting applications. I checked this morning. However, the SBA has encouraged eligible participants to get their documentation all buttoned up and also create your sam.gov account, which is the system for award management of which you will submit your application and also receive funds. Okay, so that's a broad overview of the programs out there right now. And now I wanted to get to more pointed issues regarding the PPP. So the first item that I wanted to talk about has potential large implications for our not-for-profit clients out there. So for the second draw, as many of you know, as to be an eligible recipient of the second draw loan, you had to show a decrease in revenue by at least 25% in 2020 in a quarter or annually in 2020, as compared to a quarter or annually in 2019. So what is gross revenue? The SBA regulations issued last month had a definition of what gross receipts meant for our for-profit clients, and it was fairly comprehensive. However, for our not-for-profit clients, they simply cross-referenced to a section in the Internal Revenue Code, which essentially had the definition of gross receipts within the context of filing your 990. So the issue presented with multiple clients of whether or not in gross receipts you include or not include unrealized revenue, those unrealized losses and gains throughout the year. So we did some digging, and we have been recommending to clients to, or for our not-for-profit clients, to not include that unrealized revenue and to be consistent amongst your reporting requirements for the 990 for 2019 and 2020. For our not-for-profit clients who do not need to file a 990, the issue of consistency may not be an issue. However, we are still recommending to exclude those items that wouldn't be reported on a cash basis, which would not be these unrealized revenue. So that issue has potential large implications for not-for-profit because it could determine whether or not you satisfy that decrease in revenue. All right, so that's one issue that we've been getting a lot. A second issue that I wanted to just briefly talk about was affiliation. Situations pop up where you have an entity that may qualify for that reduced revenue requirement. However, another entity in your corporate structure may not have that decrease in revenue. They might have had a really good year. So we have been we've been conducting affiliation analyses for our clients, which really rests on ownership allocation as well as control and management of the entities. So it's highly individualistic, and we need to look at the specifics of your companies. But for purposes of calculating gross revenue and gross receipts, you have to aggregate all of your gross receipts of your affiliated entities when determining that decrease in revenue. So affiliation has been on the forefront for a number of clients. A third issue, and what I wanted to conclude upon, was, of course, the economic uncertainty and necessity certification of the PPP. This was a huge issue last year. It still remains an issue. You still, when you submit your first and second draw applications now, you still need to certify that in good faith that economic uncertainty necessitates the PPP. So we've been doing individual analyses of clients of their access to liquidity and whether they can meet that good faith certification. So that's my cap. And if you have any questions, please do not hesitate to reach out to me or to anyone at Bond, and we'd be happy to help.
Thank you, Liz. Appreciate that update. We're going to turn now to Teresa Rusnick. Teresa's in our Rochester office. There have been some recent developments at the State Division of Human Rights. This is not COVID related, strictly speaking, but we think it's of interest. Teresa, take it away.
Thanks, Pete, and hello, everyone. For those of you that haven't had the experience before the Division of Human Rights, I'll just briefly recap what the Division of Human Rights does. It's the state agency that enforces New York State workplace discrimination statutes, and individual employees or former employees can make complaints to the Division of Human Rights within a set period of time of discrimination that they believe they've experienced in the workplace. The Division of Human Rights will process the complaint through their administrative process, which will eventually end up in hearing if it gets to that point. Since COVID has started, and really even before COVID, we saw the Division of Human Rights getting increasingly delayed in their processing of these complaints, particularly in the stage after the complaint had gone through the initial phases and it had received what's called a probable cause determination. After that point, the division's usual process is to schedule a hearing before an administrative law judge. And since COVID, we had seen that the time between that probable cause determination and the hearing was increasing rather severely, to the point where it was a year or more between when you would get that initial decision sending you to a hearing and you would actually be able to go to a hearing. So in an effort to essentially speed up this process or to prevent more cases from getting to the hearing stage, the Division of Human Rights has launched what they're calling an early resolution pilot program. This is for complaints where there's been a determination of probable cause. but no hearing has been scheduled and there's been no pre-hearing settlement conference. Now, for particular matters in that phase, the division has picked 300 individual ones and has referred them to this early pilot program. Again, it is a pilot, so the Division of Human Rights may tweak it or make changes to it before they roll it out officially, but they have selected 250 to 300 matters to be part of this program. And really what it is, although they haven't used this word for it, is a mediation program. It's designed to get the parties to settle the case without them having to go before an administrative law judge and have what's essentially a small trial. So it's designed to be 4 weeks in duration. The Division of Human Rights will assign a settlement representative to the parties. If they agree to participate in the conciliation, both parties have to agree. The parties don't give up any substantive rights if they participate in the conciliation program. If the program is unsuccessful, they just return to the regular hearing calendar before the administrative law judge, as if they would even if this program didn't exist. It is for parties that are both represented and non-represented, so it doesn't matter if the employer is represented and the employee or the complainant is not, or vice versa. Both parties have to opt into participating. And if, at the end of 4 weeks, if the parties haven't reached a settlement, they get returned to the usual hearing calendar and can go forward with a hearing before an administrative law judge. So again, this is the first time the Division of Human Rights has ever done anything like this. I have had a number of matters get referred to this program, so we can continue to keep you updated as that goes forward. I think the intention behind the Division of Human Rights starting this program is to shorten that time between the probable cause determination and the eventual resolution of the case, which, as I said, has been especially slowed down because of COVID. So Pete, I think that's what I have on the early resolution program.
Great, Teresa. Thank you. You know, and early resolution, I think, can be a helpful tool if resolution is where we're headed. Obviously, if it's not something that can be resolved because of the facts of the case or the principles involved, then this is probably going to be ultimately a non-event for a lot of people in that situation. Okay, let's turn now to Katie Anderson. Katie's in our Albany office. She does a weekly update for us, and things do not seem to be slowing down on the Albany front. Katie, take it away.
That's right. It's called job security, Pete. Things have not been slowing down at all. And they will looks like it's not going to continue to slow down. So let's start where we've been starting over the past few weeks, looking at the numbers. We've seen a pretty steep drop off in New York of our positivity rate. This is the number of cases. That's that 7-day average of cases in New York. So it's going down. It's still pretty high. When you're looking at that chart, we're still in November, December numbers of our 7-day average. So that's still significant. But because of the downward trend of cases, we are seeing things reopening. The governor's office has announced reopenings of movie theaters in New York City, amusement parks, the billiards halls, and the list continues to expand. We had a phone call with the governor's office this morning, and they were talking about how they are trying to do this where they're giving people more notice about how reopening will go. Since the vaccine is really such an effective weapon against the virus, they are able to give such a longer lead time into how we are going to have reopenings and where we'll have those reopenings. Looking at the vaccine, this is a different graph than the one I used last week, but I like to look at when am I going to be able to leave my house, right? That's, I think, the question that everybody's asking. When are we going to be able to do things again? And at the current pace of our vaccination in the United States as a whole, 50% currently on the current trajectory would be vaccinated by July 19th. That's great news. Hopefully we can get it to be sooner. The past week, we've seen bad winter storms throughout the country really snarl the distribution of the vaccine. So that's really slowed things down. Hopefully we'll be able to pick up the pace again. In the past week, we've seen about a 2% increase in the number of New Yorkers vaccinated. Last week, it was 10.3% of New Yorkers had received one dose. Now we're at 12.4. 6.3% of New Yorkers have received two doses. Last week, it was 4.3. So that's good news. We're seeing this update and looking forward to having an effective vaccine system for all of us. One thing to note, the South African strain has been found in New York. That is the strain that the AstraZeneca vaccine is less effective against. But we haven't approved that AstraZeneca vaccine in the United States, and the Pfizer and Moderna vaccines, which are the only two that you can receive in the US at this point, are just as effective against that South African variant. So we will continue to watch those updates very closely. I know that matters greatly to everybody. Before we go into some more questions about the vaccine, this was announced yesterday. This is a new policy for nursing home visitation. The governor announced this yesterday on a call with the press. Beginning on Friday, people may visit nursing homes based on the county positivity rate. So if there's less than a 5% positivity rate in the county, no visitors need to be tested before they go to the nursing home. If it's between a 5 to 10% positivity rate, testing is required for visitors within 72 hours of going to the nursing home. If, however, you have received your 2 vaccine doses, and the last dose was received more than 14 days ago, you don't have to be tested so long as you received the vaccine in the past 90 days. That's a lot of different timelines at play, but just remember, if you got your last dose more than 14 days ago and you're within that 90-day period, you don't have to be tested to go visit a nursing home resident. If the positivity rate in the county is greater than 10%, no visitation is allowed except compassionate care. This is a big change. Hopefully this means that people will be able to get in there. There are also limitations on the number of visitors that may be in a nursing home at a time. The guidance hasn't been published yet. So this is just based on what the governor said yesterday in his press conference. This, as we know, what he says in the press conference, by the time it comes out in writing, there are changes. So we will see what the actual policy is going to look like. But again, it begins on Friday. So that is good news for people in nursing homes and for your family. The travel advisory, gotten a lot of questions on the travel advisory. So I thought it would be a good time to just run through a really quick refresher. There is no vaccination exception to the travel advisory, period. That's the end of that. The state has not said that there is. We haven't seen any unofficial policy from the Department of Health saying that that's the policy. There is no exception to it. The reason for that is what I was discussing earlier about the variants. You don't know if the vaccine is going to be 100% effective against all the variants. Also, remember, there is a chance that that the vaccine won't necessarily work on you. A small chance, but there is a chance. And there's also a chance that if you travel, you're more likely to come into contact with people, and you may still be spreading the disease when you return. That's why the travel advisory, there's no vaccination exception at this point. That doesn't mean that there won't be in the future, especially when you start to see vaccination rates increase. But at this point, there's no exception. You have to follow it. There is an exception, though, for being exposed to COVID-19. Let's go with this example. If you're an asymptomatic, fully vaccinated individual, and what does fully vaccinated mean? It means that you've received your 2 shots and 2 weeks have passed since that second shot. So if you're a fully vaccinated individual, you are asymptomatic, you come into contact with somebody who has a suspected or confirmed case of COVID-19, within 90 days of receiving that shot, you don't need to quarantine. So that's a shift that came out in a press release from the Department of Health last week. So that's a change, but that is the policy now. That is an official policy of the state. If you have the vaccine, you do not need to quarantine if you are exposed within 90 days of receiving the vaccine, so long as you're fully vaccinated. What else is happening in Albany? This has been really the big question that a lot of people have been asking me. What's going to happen with the governor? The governor is taking some really big hits right now based on the nursing home fallout. The legislature, the two houses, the Senate and the Assembly, are currently split on a few things. One, they're split on nursing home reforms. The Senate passed a raft of nursing home reform bills yesterday, and the Assembly has their own proposals. So they've got to meet somewhere, and right now they haven't met anywhere. The governor last week also proposed in the budget additional nursing home reform measures. So we have 3 active reform measures on the table right now. So we don't know what's going to happen there. But turning then to the emergency powers, there's been lots of talk. There's been talk about impeaching the governor. There's been talk about revoking the governor's emergency powers. What does that mean? I discussed that last week. I've been in contact with lots of people in the Capitol. The legislature is very aware of what would happen if these powers were revoked. They have assigned basically committees to study the committee staff to study all of the executive orders to make sure that nothing, if the powers were revoked, would really be disrupted. They don't want to create a disruptive measure with revoking the emergency powers. So that's good news. But there are really 3 options for how the emergency powers would be revoked. First one is they expire on April 30th. That's just, and nobody does anything in the interim period. They will just expire on their own on April 30th. That appears to be the least likely measure of what will happen because by April 30th, this crisis is not going to be done. So there's a good chance that there will be an extension of those powers. The second option is that the reform would go in the budget. It hasn't been introduced in the budget yet, but that doesn't mean that it won't be. The budget's due on April 1. So it could go in there. The governor has a lot more control over the budget. So the governor would be able to propose that legislation to go into the budget. And then finally, the reform passes the legislature as a standalone bill. But the 2 houses, they don't agree right now what the reform will look like. That doesn't mean that they won't agree in 2 weeks or even next week, but they don't at this time. So we're keeping a very close eye on this situation. This could really have a big impact on everybody. And with that, Pete, I am done.
Katie, before I let you go, we got some questions here in the chat about, does the 90 days mean that the vaccine is only effective for 90 days? Does this mean that, you could be fully vaccinated and still transmit the virus? My sense, what I'm going to ask you is that we're not certain about the science of how long the vaccine would protect. We're not certain of how effective the vaccine is going to be against variants, known and potentially unknown. And so these are rules that are being fashioned based upon, scientific information, but, I don't want to use the word guesses, but the best estimate of what might be safe. Do you have comments on that?
Yeah, that's absolutely, the track that we have to go on right now. There's 2 points. One, we'll go with the 90-day provision. 90 days that's all we know because that's all the tests were beforehand, was to see its effectiveness 90 days out. So because this vaccine is so new, we don't know necessarily if it will be forever, or, for 5 years, it would be effective. You think about your tetanus shot, you have to get that regularly. But that doesn't mean that 90 days it's going to just disappear. I don't think that's the case. Most scientists don't think that's the case either. 90 days just right now is a cautionary measure. Based on the conversation that we were having with the governor's office this morning about reopening, they are constantly just looking at trends, everything daily. And it's on a daily basis that they are updating these guidance to examining them, basically. So don't be surprised if that 90-day thing falls away. By the time we get to 90 days from when the first New Yorkers received the vaccine, I wouldn't be surprised if that 90-day measure goes away. It's just in place now. I don't think it really goes to the efficacy of the vaccine. What was the second question that you had?
Well, it was the 14 days.
The 14 days. Yeah. So that 14-day thing, when you look at these studies, and I've had the fun opportunity to look at some of them, it's a lot of convoluted stuff in there, but ultimately the way that it works, and again, I'm not an epidemiologist, so I'll try to break this down as simply as I can. When you receive the vaccine, your antibodies build up over that 14-day period. So by the time you reach that 14 days, you are at the maximum level of what your antibodies would be to fight COVID. You see lots of things, like, for example, there was a 104-year-old who received both vaccines on the second day. The day after she received the second vaccine, she tested positive for COVID, and she was just fine getting rid of it. So it's not necessarily a cut and dry rule that it's not effective after up until the 14 days, right? It's effective after even the first shot. That first day that you receive it, you are building those antibodies up to fight the virus. So, these numbers are in place, not necessarily because the vaccine doesn't work, but just because we don't really have better numbers to go on.
Yeah. I guess the other thing we're seeing in the comments is, sort of the lack of symmetry between, the travel advisory and the exposure guidance, which, was called out pretty directly in your slide. And again, these are judgments that are being made. They're evolving, they're changing. But currently that's where we are in terms of the judgments that are in place at the moment.
Yeah. And I mean, based on how the travel advisory has developed, I don't necessarily think we're going to ever go back to the rotating slate of states, my map that I would update every week for you. I don't think that we'll be going back to that. And I'm not confident that we're going to be rid of the travel advisory anytime soon. I personally am expecting to deal with the travel advisory throughout the summer. So I'm basing my summer plans around that. Yeah. It's just, I think that's how it's going to go. But, we aren't necessarily the decision makers, and the decision makers, it's a very small group of them. These are the decisions that they're making.
Fair enough. Okay. Thank you for that. Let's shift gears here. We're going to do a couple of presentations on remote work. Obviously, this is a phenomenon that we've seen a lot of. I think initially everybody thought, well, it's short term. We do that, as it becomes, I'll use the word robust or embedded, I think it's time to think a little bit more deeply about what some of the issues are. So we're going to have a couple of presentations on this. Sam Burgess is going to start us off with a discussion of some of the tax and payroll issues.
Thanks, Pete. So as you said, initially, I think when employers started to work remotely, work from home, no one really thought about these potential tax and payroll issues. It was what's convenient for the individuals, how can they, get their job done, and no one really cared where they were doing it at. Now, as time has passed and it's continuing to go forward, the question has turned to what potential tax liabilities are there for employees and employers when the employee is, doing that remote work out of state, whether it's for a short period of time or they've been doing it for the whole period, whether, they're someone who commutes into the state and now they're no longer commuting into the state. So with that being said, there are some states that have reciprocal agreements like New Jersey and Pennsylvania, where, if you live in one state, work in the other, they have a reciprocal agreement regarding handling of taxes. New York does not have such agreements. Therefore, New York sets its own rule, and it follows a rather strict and rigid, what they call convenience of the employer rule. So basically, the way that it works is New York takes the position that if your primary office is in New York for the employee, then the income, their wages are all subject to New York taxes, regardless of where they're performing the services. If they're at their home in New Jersey, if they're at their home in Florida, they're still subject to the New York withholding. And as a New York employer, you have to withhold all the wages pursuant to that requirement. The employee obviously would be subject to the New York withholding, the New York taxes, and they may be subject to the other state's taxes, depending on what state it is and what laws they currently have in place. So as I said, that's the general rule. The convenience of the employer rule generally takes place where, all income, all wages are subject to the New York withholding requirement. There is a way around that, an exception, but this exception we have found isn't really applicable in this remote work situation that we're currently in. That exception is if you can say that the employee's offsite remote home office, more or less, is a bona fide employer site. And that's usually found by different things. There's a whole list of factors, but that can be determined based on, there's no employer office for the employee to go into. A requirement of their employment is that they have this outside office. They have a separate phone line. The employee's address is listed on the business website, things of that nature. So things that generally haven't come into play or that we haven't seen in this context. Therefore, we've been going under the general rule that, the New York standard is that you must withhold for all the wages. The next step, though, is to see if there's any other requirements. Are there requirements to withhold in the state that the employee is located in and is working for the current period? Some states require it, some states don't. Some have COVID exceptions. Some haven't provided any special COVID guidance. So this is a spot where it's going to have to be a case-by-case determination. You're going to have to look at what states your employees are providing services on, what guidance there may be, from a general standpoint, what COVID-specific guidance there is, and then, discuss it with your attorney and or your tax professional to determine, what requirements there are to withhold. So, just for an example, some of the states that have come out with different, guidance at this time, California has made it clear, you have to withhold, the employer has to withhold for the portion of the year that an employee spent in California. South Carolina says if the remote work's due to COVID and it's this temporary time period, it's not a permanent relocation, you don't have to withhold taxes there. Virginia hasn't changed anything. You have to follow, normal withholding requirements. You'll have to withhold for the time that your employee is in Virginia. Georgia says, if you're temporarily in the state because of COVID, an exception applies and there's no withholding requirements. But their exception, unlike South Carolina, it kind of has a blanket exception. Georgia seems to be more limited, where it has to be you have basically a stay-at-home order from, federal, state, local government, or you have an order to quarantine or stay at home from your doctor or the local health department. After those scenarios expire, it appears you would then be subject to having to withhold in Georgia as well. So this is an evolving area that, you know, definitely differs based on what state you are in. And it's something that you are going to want to look at, like I said, on a case-by-case basis. But also you should know that while you're looking at the case-by-case basis of, you know, the tax withholding, the payroll issues this may cause, you should also look at the potential registration requirements for doing business as a foreign entity in such state. You know, some states have, you know, made it clear simply having employees in our state, you know, teleworking isn't sufficient to establish a nexus to have to register as a business in our state. However, other states it's not as clear in. It's not set in stone that, you know, just having employees there is going to preclude you from having to register. So, I mean, that is one other thing you're going to want to look at is, you know, do you have a business nexus in that state now? And are you required to register in that state to be performing, you know, to have your employee there doing work for you? So, I mean, like I said, this is just the basics of some of the questions that we've seen in the last, you know, couple of months regarding, you know, an issue that's come about that people weren't thinking about originally, but it is something that you need to be aware of and need to make sure you're looking at, you know, to make sure that your withholdings are done properly, make sure that your employees are, you know, on the same, you maybe want to tell your employees that, you know, they may have the same, you know, double tax requirements for, you know, pay tax in 2 states, and, you know, that they can get a credit on one of the states usually, but I mean, it is something to be aware of and that make sure you are following. And with that, Pete, I think we can turn it back to you, and Andy's going to get into some more remote work scenarios. But I just want to say, you know, again, you know, reach out to your attorney if you have employees who are out of the state, because it's going to be state specific, and the guidance has to, you know, follow which state your employees are in.
Yes, Sam, good point. And I think, you know, as time goes on, 2 things. One is, you know, the exposure, the potential exposure is greater because there's a longer period of time where these issues could have arisen. And then the second is that it's less likely that people will say, well, this was a short-term thing, we can, you know, we'll just, it's de minimis, or, you know, it's not worth pursuing. So a little heightened scrutiny here. We're going to turn now to Andy Bobreck. Andy's got sort of the employment side of this coin.
Thanks, Pete. Good to be with everybody again today. Yes, I'm going to dovetail off some of what Sam talked about in terms of remote work. I'm seeing this come up in a wider variety of circumstances, right? We had the operational needs initially that, hey, everybody's working at home, places are closed down, and certainly that continues to be the case today. I'm also finding that many of our clients, for either retention or job attraction purposes and recruitment purposes, are looking at these arrangements and having somebody work remotely in another state, because it allows them to keep or bring on talent that they wouldn't otherwise be able to have. Nonetheless, it raises the same types of tax and registration issues that are coming into closer focus. I want to cover a few of the labor and employment issues today. This is not an exhaustive list, but I want to help you spot these issues and be able to articulate them. Many of them I suspect you're able to spot already. I think tangentially, this also gives HR a chance to kind of flex, right, for leadership. There's so much that you need to know, and this is a great way for you to be able to articulate exactly the breadth and depth of the knowledge that you need to have as an HR professional or handling HR for your particular organization or business. As a threshold issue when it comes to remote work, we need to look at, all right, who's going to be able to connect remotely? Who isn't going to be able to connect and perform their work remotely? It's going to depend, of course, on your organization, the type of work that's done, but it's not necessarily going to fit for everybody. And I think that's an important distinction, because inevitably, right, you're going to get a question from somebody that says, hey, I'd like to work remotely. And if we're going to approve it or not approve it, what are the rationale that we're going to have behind that? Because we're going to want to be able to articulate that, to be able that show that we're treating people fairly and, of course, in a non-discriminatory manner. Likewise, I think it's important to have buy-in from leadership within your organization or business, and making sure that they're aware and that there's an assessment of the legal implications of engaging in this type of remote work in another jurisdiction. I think that's key. And a lot of what we'll talk about, I think, applies not only if we're considering it here in New York or in another state, right? A lot of these principles apply generally too. The location, I think that's going to be key, as Sam alluded to. If we have the remote work being conducted in another state, that potentially brings into play the laws of that jurisdiction. Think about it here in New York. If we're just a New York employer, we need to deal with all things COVID, of course, but we need to deal with paid sick leave, paid family leave, the Wage Theft Prevention Act. We have mandated sexual harassment training and policy disclosures, right? And this is true. Similar requirements are in place in other jurisdictions as well. And by having somebody situated and performing work remotely in that jurisdiction, we could potentially trigger those laws and need to be mindful of that. So again, it's important to be cognizant of that, get the right legal advice that you need with respect to those potential jurisdictional issues. Likewise, what type of equipment does the worker need? Is everything already available? Do we need to supplement that equipment? How are we going to handle expenses and the reimbursement of expenses that the employee may incur while performing that remote work? And there, it's key to remember too, that can implicate wage and hour laws and minimum wage laws too. So we need to be mindful of those points. For our non-exempt employees, making sure that we're clear to them, if they're going to be working remotely, what the job expectations are. We expect you to be performing X, Y, and Z. Having those expectations clearly delineated, making sure we communicate how they should be reporting their time. And this may require us to implement some kind of new timekeeping procedure. And of course, we want to make sure that we reiterate the importance of accurate reporting at time, as well as the penalties for falsely reporting time, and have that information communicated to the employee. Again, if somebody is performing unauthorized overtime, let's say, ideally, I like to have a provision that says you shall not perform any overtime work unless approved in advance by a supervisor. But if we get, I think this is important here to have that type of disclosure to the employee. But if that work's performed, just remember, we can take disciplinary action. But if that's bona fide work that's still being performed, in all likelihood, our advice is going to be to still pay that time, take the disciplinary action, but still pay that time. If we see on the next slide, there's a few additional points that I'll cover just very quickly as we have a couple minutes left. The work from home arrangement can bring into play certain OSHA and workers' compensation issues. Again, if an employee is injured at home while working, that can bring into play a workers' compensation claim, and in theory, an OSHA claim too, but perhaps to a lesser extent. What I like to have here is a clear delineation and understanding what the work area will be at home for the employee, what tools will be required. Right, for me, it's a laptop, mobile device, not much else besides that. And then where at home that work is going to be performed. I think we want to be clear about any potential limitations, right? Hey, you're not going to need to drive anywhere to perform your job. And the objective here is to appropriately describe the scope and course of employment, right? So that's where the workers' compensation or work-related injury is going to be covered. But if it's beyond that scope, well, then it's not necessarily going to be covered. And we want to define that. I think also we don't want to lose sight of the importance of performance management. Just because somebody is working at home, I think there is this difficulty, right, practically that arises in being able to manage the performance. And then I think sometimes there can be the sense of, well, nobody's looking over my shoulder right now, so I have a lot more flexibility on how I do this. And that can be true, and it can work in certain circumstances, but not always. And I think you need to be mindful of, all right, how are we going to make sure that work is still being performed in an appropriate and proper manner, just like we would if we were at the office together. We do have tools that we can use to do that. We can conduct electronic monitoring of our employees. We're going to want our policies to very clearly delineate what we can and may do with respect to that monitoring. But we can check on an employee's emails, right, using our system. We can monitor their internet usage through their work-related computer. We can track their keystrokes. We can monitor their login activity to make sure it comports with the hours that they're reporting. These are tools in our toolbox that we can use. I'm not suggesting we have to do this for all employees all the time, but rather we may want to do some spot auditing just to make sure that, again, that employee who is representing us, who's doing our work, is doing so in an appropriate manner. I think second to last, cybersecurity. I think I can't emphasize this enough. We're going to have an employee who's going to be connecting perhaps remotely to our servers, to our networking drives. We're going to want to make sure that those connections and those means of access are secure. How do we authenticate logon information? Do we use a two-factor system? Have we trained our employees on the critical importance of cybersecurity and taking appropriate precautions when connecting remotely? Do we have a VPN set up? These are things that either your IT consultant or your IT staff can certainly weigh in on, but again, can't emphasize enough, very critically important. Finally, Pete, just in case, if you're in a unionized work environment, you have a collective bargaining agreement in place, and you're talking about remote work for bargaining unit employees, there can be a NLRA collective bargaining obligation that arises there. Again, you're going to want to talk to your bond attorney to address those issues. All right, Pete, I went a minute over. I'm sorry about that. I guess I would just wrap everything up by saying, you can see there's a lot going on with these issues, right? And for me, what makes the most sense, I always like to have documentation. If you've worked a case with me, that's the first thing we talk about, is what kind of documentation we have in place. I like us to have an agreement that addresses these issues, that protects the organization. It's good for us. And frankly, it's good for the employee to set forth those expectations. And then, of course, maintaining accountability on the back end. Pete, thanks. That's all I got.
Thank you, Andy. And I think to your last point, it's another one of those things that, that bears taking stock of now. When we went, remote sort of in a hurry, we just did the best we could with it. Now, hopefully, we have a chance to take a breath a little bit and be a little bit more intentional about it. It certainly should be, I think, on our list of things to rationalize and deal with in an intentional way. Whether it's at the top of the list with, the urgency of today, maybe not, but it should be, something that we should try to get to pretty quickly.
I agree. Yeah, good advice.
Okay, everyone, thank you so much for being with us today. We appreciate it. As always, we look forward to speaking with you again next week. In the interim, please stay safe.